Let's talk about this for a second, Amy Lee. The concept of the trial in Fulton County, Fani Willis has said she'll be ready to go around August-ish, but because of issues having to do with the appeals on the federal trials, the judge did ask, how much time would you need if this trial could go earlier? And the lawyer said about 30 days, which means this trial could be the first one.
It could be, Allie. It could be any time between now and 2029, apparently.
That's right.
But the state, yeah. But when asked, the state said it would need about a 30-day jump to subpoena its witnesses. They'd had a trial run with that with the Chesbrough and Powell trials that simply didn't go forward. So they're ready to go. But you also heard the countervailing claim of Eastman, who said, listen, I just can't wait around until 2029 to do it. And that led Judge McAfee down other roads, like, would this be tried as two buckets of defendants? Would this be tried as 8 defendants each and possibly Trump by himself? So we came out with a lot more questions than we had answers for about the timing of the trial after today's 6.5-hour hearing.
Let's talk about this First Amendment business, Joyce. In fact, not in this indictment, but in the Jack Smith indictment, I think it's the second or third page. It's very, very clear. Everybody needs to just dispense with this First Amendment thing. Everybody's got a right to lie. Donald Trump has a right to lie. He's got a right to lie about the election. He's got a right to lie about the outcome of the election. He can do this all he wants. He can pursue his remedies. But once he's pursued all those remedies, and he still feels like lying about it, he doesn't actually get to take action to overturn the outcome of the election. That's what Jack Smith has said. This is the Fulton County story. Are the First Amendment claims similar and related?
They are. These are the same sorts of claims. And we saw the judge in Washington, Judge Chutkan, who we were discussing earlier, dismissed these sorts of First Amendment claims. The same argument applies in Fulton County. When your words are an instrument used to commit a crime, they're not protected by the First Amendment. So if Trump said, to a random person on the street, put your hands up, I'm going to rob you, certainly those comments wouldn't be protected by the First Amendment. They would be part of committing a crime. Same thing holds true in Fulton County and in D.C., where speech is used to commit crimes, it's not protected. And of course, as the DA's lawyers were quick to point out, the reason that there's not been a prior prosecution has nothing to do with the First Amendment. It has to do with the fact that no president has ever been part of a conspiracy to overturn an election before this.
Interesting, though, Amy Lee, the Trump attorney did seem to be sort of floating this idea of alternative facts, right? The idea that one person's truth is another person's lie. There is some danger about these trials becoming trials around the First Amendment, despite the prosecution's efforts to dispense with the notion that these are First Amendment prosecutions, because they're not. Donald Trump, in his social media, in his speeches, wants to call them both First Amendment issues and election interference in both cases. And I suspect that's not going away just because a judge says so.
Of course it isn't. And to piggyback on Joyce's answer, I think it's interesting. I actually looked up to see what the ACLU's position was. And a few weeks ago, it published an op-ed saying that a staunch defender of First Amendment rights, who'd actually defended Trump various times, including being upset that he got kicked off social media for exercising those rights. Even the ACLU has come out and said, this isn't a First Amendment case. But go back to your question, the real issue at today's hearing was exactly when could the judge determine these First Amendment issues? Did he have to wait until during trial when the evidence started coming out, or was there any avenue that he could determine them prior to trial? And for the first time today, the defendants floated that there was a case that they found from Georgia that said that the judge could actually determine these issues before trial. So there was a lot of hullabaloo about what would the defendants have to stipulate to have the judge determine this. Ultimately, though, this isn't going to be a successful claim. I mean, this is not a First Amendment case. The rubber meets the First Amendment road when talk turns into action, and there was plenty of action here.
Joyce, you and I talked in the last block about what Scott McAfee said about, we heard it, the exchange about when Donald Trump is running for president and when this can be tried. Tanya Chutkan had a conversation about this as well today, and she released information in her decision earlier about campaigning. And I want our viewers to compare what they heard in the Fulton County Court to what Tanya Chutkan wrote. She said, when a first-term president opts to seek a second term, his campaign to win re-election is not an official presidential act. The office of the presidency as an institution is agnostic about who will occupy it next, and campaigning to gain that office is not an official act of the office. Tell me how that thinking applies to what we're hearing from Donald Trump's attorneys about the fact that he can't be tried while he's campaigning, and then he certainly can't be tried when he's president again, if he's president again.
So that's a really interesting question, because that's extending the analysis a little bit further. The argument that Judge Chutkan has made is that President Trump might be entitled to certain immunities, but candidate Trump is not. Candidate Trump is responsible for his conduct. And so there's an interesting question of whether status as a candidate means that Donald Trump can't be put on trial. That will be a question that perhaps Judge McAfee will have to sort out. It was interesting because he extracted a concession from Steve Sadow. He said, if your client is not the Republican nominee, then nothing prevents him from going to trial, right? And Trump's lawyer was forced to acknowledge that that was correct. That doesn't mean, though, that Trump is able to avoid a trial just because he's a candidate. And there will be good arguments offered by the district attorney for taking him to trial, regardless of whether he's a candidate or not at the time.